Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about a group of pharmacies. 6 pharmacy businesses. 3 of them are run by a partnership between 3 pharmacists. The 4th is run by a partnership between those 3 pharmacists and 1 other person. And the remaining 2 are run by companies, the chief shareholders of which are the corporate vehicles of these 3 pharmacists. Don't worry too much about it. Essentially, 6 pharmacies run as a group with a sort of management board that oversees the way they work. Now, complexities arise, which is to say disputes arise, and the various relevant people in relation to these pharmacy businesses don't get along. We've got a general manager who sort of oversees the group, who's dismissed in difficult circumstances. We've got a bit of a negotiation towards a buyout that doesn't really get anywhere. And in the background, we've got a financier who has become aware of the disputes and is just reflecting on whether or not to call on some of the loans made to the group. So all this crunchy stuff's going on in the background, and the plaintiffs, which is to say some of the relevant people involved in the group, approach the court to seek a dissolution of the partnerships, 1, 2, 3, 4, and a winding up of the companies. And the basis they are seeking those things is that it will be just and equitable to so wind up, because in essence, the management of the entities has got to a position where there's essentially a deadlock. The parties are unable to go ahead. So the plaintiff comes to court and the defendants agree that the partnerships ought to be dissolved, and they agree that the companies ought to be wound up. And so the court considers who are the appropriate administrators, in this case liquidator and receiver, to be appointed. And there are competing insolvency practitioners who are considered. Both of them look very respectable. Both of them charge a very similar price, and indeed the slightly higher priced practitioner agrees to reduce prices to make sure the prices are equal. But the court errs in favour of the insolvency practitioners that have an in-house pharmacy administration bit of experience. So they've done a little bit of winding up of pharmacies, a little bit of receiverships of pharmacies, that sort of thing. And the court finds in favour of those insolvency practitioners, in favour, as it were. The court decides that they ought to be appointed to run the receivership and run the liquidation. Easy. So all that's left is legal costs, right? Remember how I said to you before that the plaintiffs said, look, we can't get along, and so it's just and equitable that the partnerships and the companies should be wound up? Yeah. The defendants agreed. They said, yeah, look, that's pretty much right. And the court ended up making the orders. And so the proceedings weren't really adversarial. They weren't really a direct confrontation between plaintiffs who were vigorously seeking something and defendants who were desperately resisting. In essence, it was a more agreed path towards dissolution of these various entities. And so what the court found, well, the court didn't find this, but the court has a very broad discretion in relation to making costs orders in these sorts of scenarios. And what the court decided was that the plaintiffs, the people who made the application, they've incurred some costs in relation to preparing the necessary evidence for the court to decide about a dissolution. And so they shouldn't have to bear the costs of that, because that had to be incurred. And so those costs were to come out of the partnership and company assets once they were wound up. The defendants' costs, the sort of other side who were notionally resisting the application, well, they had to go and pay their own costs. And so what the court ended up finding in a non-adversarial conflict, as it were, was that the applicants didn't have to bear the cost associated with making the application directly. They would come out of that joint pool. And what I hope is that that quick little tour through the dissolution of some partnerships and the winding up of a couple of companies assisted you. I look forward to talking again soon over another coffee while we have or discuss another case note. Cheers.